Yesterday was that FCT is like every other state.
It has to be. It has to be, because I've always said so and emphasized that the Constitution does not leave you to guess. If it wants to say something, it says so, and it always means what it says. To give the FCT some sort of peculiarity and a status that is over and above the others, it has to be emphasized, clearly stated, and the reasons given in the Constitution, and not for judges to make some form of analysis or reasoning on the grammar that was used. You know, I have had to say this over and over, that it would be a disaster for the Court of Appeal to rule otherwise, because there is no basis for it. The FCT is just like any other state, and the citizens and inhabitants of the FCT are just like any other citizens and inhabitants of the other states. So why would you expect some form of a special status? You know, people would say, oh, in the US you have that. Of course, they had it, and it is stated in that Constitution clearly. So it's not one that it's based on a guesswork or a judge's interpretation. It has to be there.
And there were insinuations that there were previous Supreme Court statement on this, indeed clarifying that what you really need to win in FCT is 25%. I think Buhari versus Olusegun Obasanjo in one of the presidential elections. That didn't come into consideration?
No, that was never really a judgment. You know, they were just very dismissive of it to say it's a no issue. You know, there was never a time they gave that one. And that
it's not a judgment, but they made a statement alluding to that.
No, you see, the FCT, in all judgments, it's just like any other state. And the Constitution is clear. It says just like any other state. So I can't imagine circumstances that would justify giving it a special status. And to me, that was a no issue. And I think there was one point that I had to say, that if the Court of Appeal spent more than uses more than 2 paragraphs to dismiss that issue, then it's been very magnanimous, you know, because it's a no issue. Trust me on that.
It's just that on the streets, people are still trying to grapple with that reality, the position taken by the Court of Appeal. There's no governorship election, only 1 Senate or 2 House of Reps. They point at several unique characteristics of the FCT to insist that it is perhaps a different capital territory, not similar to others.
You see, of course, somewhere along the line, its characteristics have been distorted, but it was meant to be the federal capital and having the status of a state and being ruled like any other state. That's the literature that I know, the law that I know, any other insinuation. You know, when this narrative was thrown out there, I felt for the litigants, because they believe that narrative. They are not lawyers, you know, and even within INEC, it was very obvious that they were divided on it. They had to call some people to make clarifications on that, you know, because there are some of them that felt otherwise. You know, because when some of our senior colleagues that are well respected and people know them for their pedigree, throw in a kind of a slant, the public is bound to hold it very dearly and act upon it. And but I had thought that that was unfair on the litigating public, because you could see how much of a belief they put into it. Look at the passion of people like the vice president of the Labour Party. I watch him, I say, oh, there, this gentleman believes absolutely in this narrative. And I think it was unfair. But it will soon be put to rest, because I can tell you for free that the Supreme Court would uphold that very particular decision in respect of the FCT. So
you're speaking with a lot of certainty.
Definitely. And trust me on that.
Well, we'll see.
Yeah.
Let's hear what the Supreme Court will say. The other issue is that of nomination. The court said is something that, and qualification is something that is pre-election.
Nomination, sponsorship of candidates is pre-election. Qualification aspect of it, especially disqualification, is a pre-election matter, and the Constitution is very clear. So you have to ventilate that at the High Court or the Federal Capital, the High Court of the Federal Capital Territory, or any of the High Courts of the States of the Federation within 14 days, of the awareness that this nomination was wrongly done. But in any case, the much more serious aspect of it is the issue of who has the rights to espouse a right over it, or who has the right to make a case against the wrongful nomination or wrongful sponsorship. It has to be a member of the party, and the law is clear. It said you must have participated in the primary that produced the supposed sponsored candidate, nominated candidate, before you could have what the lawyers call locus, which is the right to challenge it. If you are a member of another party, what business do you have with what happened with XYZ party? That's their business. If they send in the wrong candidates to the electorate, they'll be damnified. It's their business. So let them rise and fall with their candidates, not you. Because you are not in any way hot. It's the people who would come to say, oh, I ought to have been nominated and sponsored because I won the primary. Those are the people who have the locus. Not even every member of the party.
Those that participated?
Yeah, those who have participated in the primary and they feel that the law, the Electoral Act, and the constitution of the party was not adhered to, they have the right to go to court. Those are the only people that can make a case out of that. No you in another party. I think, to me, that was, if for anything, those are just whistles. Those are things that are of the wayside. Sometimes some of us would think that when you read this, say, okay, maybe this is a strategy. It could be some form of a distraction or red herring, so that they don't look at my case and where I'm coming from. But you could look at it the same way you find the APC.